Yes. Yes, Mr. Charles.
Thank you very much, my lord. I'm going to quickly finish off ground one. In my skeleton argument, footnote 10, I refer to two authorities, Smith and East, Ellow and Boddington. I'm only going to take you to the second, Boddington, which is at tab 13. I don't think it's necessary to take you to both. This was a challenge to bylaws banning smoking on trains, and the key issue was whether a defendant could raise in criminal proceedings contention that the bylaw or administrative act was unlawful. And what I seek to derive from this is on page 14 of the report in the bundle. It's from page 155 of the authority, but it's page 14 in the version you've got.
There's a marked passage at the top.
Yes, there's a marked passage at the top, but I would like you to read the whole of page 14, if possible.
Thank you. I want to sit down while we're doing that.
Thank you very much. Well,
And over page 3, presumably.
yes, I think it's the end of the quote, yes.
Yes, thank you.
Thank you very much, my lord. And the point I derive from that is, unless until a particular decision is challenged, and that challenge is successful, everyone, including the court, must proceed on the basis that that decision is lawful. And in this case, the eligibility assessments were not challenged. If a claimant can, out of time, without detailing in the N461 form, can challenge implicitly decisions without any reference to, without giving the defendant any notice of this, it would drive a coach and horses through CPR 54 and the strict time limits in judicial review. Paragraph 39, we say, and particularly footnote 11 to paragraph 39, if the claimant had sought out of time to challenge the eligibility assessments, any such application would have been resisted. If it had been successful, the council would have been in a position to put in evidence in relation to that. But it wasn't challenged. On any argument, we say it wasn't challenged. On any argument, Mr. Justice Mostyn didn't give permission to challenge it. there was there's argument about whether the 3rd of March was permission to challenge that, but on no basis we say did Mr. Justice Mostyn suggest that there could be a challenge out of time to the eligibility assessments. The skeleton argument before Mrs. Justice Lang said we're challenging the November decision, and I took you to the what is now the appellant's skeleton argument, where we say eligibility assessments aren't challenged, they're lawful. That was the basis we were articulating our case, and that was the basis on which we had adduced evidence. And it goes back to the procedural rigour cases. Parties need to know what is in issue. And the council did not know that the eligibility, the legality of the eligibility assessment was in issue until the judge below appeared to suggest that that was something within her jurisdiction. But she only has jurisdiction to consider matters on which permission has been granted. There's no permission to challenge that decision. I think that's all I want to say on ground 1. I will move swiftly on to ground 2 and 3.
Yeah.
Before I develop my submissions, I've tried to sort of set this out. Can I ask the court to envisage 4 concentric circles? So the outer circle is an individual's wishes, desires, wants. Within that, a subset, a smaller circle, an individual's needs. So, for example, food would be in the wants and desires, but it would also be in the needs. We all need food. Within that second circle, there's a smaller circle, needs for care and support. And food wouldn't be within there, we say, and we also say holidays wouldn't be in there. And within that third circle, there's a smaller circle, eligible needs.
That's a very helpful analogy, if I may say so.
Thank you.
Well put. Yes?
The question is, where do holidays and recreational activities fit in those circles? And the dispute is, the council is saying they are within the first 2 circles, or at least the broader circle. Clearly, there is a desire and a want for holidays. Arguably, there is a need for holidays, but we say it's not a need for care and support, and we also say it's not an eligible need. And the respondents say holidays, recreational activities fall in the dead centre point within all 4 circles. And that is where the dispute is. So I'm going to first address what are needs for care and support, and then look at eligible needs. And I begin this at paragraph 41 onwards. 41 is the point about hypotheticality. Yeah. I refer to a House of Lords judgment. I'm not going to take the court to it, but for the court's reference, Win is at tab 10 of the authorities bundle. I think I've made that point, and I don't think it's going to improve with repetition. Now, what we have here is needs for care and support. It doesn't say desires or wants, it's needs. Now, we say need means something more than a desire or a want. And over the shorter German, I found authority in relation to predecessor provisions, which unfortunately isn't in the bundle, and I only have it in referenced in a textbook. So if I undertake to get a copy to the court.
Yes, thank you.
The authority is ex parte Barry, and it's a judgment of the House of Lords concerning Section 2 of the Chronically Sick and Disabled Persons Act 1970. And Lord Lloyd made...
What's the reference, please?
The reference is 1997 Appeal Cases 584.
Is it a Gloucestershire case?
It was, my lord, yes. It's a well-known authority.
Yes, yeah, that's right.
And I was just going to quote the extract on the meaning of need. I'm taking this from the Care Act Manual, 3rd edition, commentary on section 9, which is not before the court, but I'm just letting you know, and I will get you a copy of the authority. And Lord Lloyd is quoted in this context about the meaning of the word need, and he said, the word need, like most English words, have different shades of meaning. You can say to an overworked QC at the end of a busy term, you look as though you may need a holiday.
Or busy morning in some cases.
Yes, you could substitute busy morning and large gin and tonic perhaps, but that's not what the court said. Then goes on to say the word need in section 2 is not used in that sense, which is not to say that there may not be a disabled person living in very restricted circumstances who may need a holiday in the sense which Parliament intended. Now, section 2 talks about holidays expressly, unlike the Care Act provision. Lord Lloyd says, to need is not the same as want. Need is the lack of what is essential in the ordinary business of living. So that's the court opining on the word need in a similar context, albeit a different statutory regime. And we say a similar approach should be adopted to the word need here. Section 9 talks about the need for care and support. So as I said, it's not all needs that the Care Act is concerned with. It's a need for care and support. And in our concentric circles example, we would say K and B have a need for food, for clothing, for shelter, for activities, for holidays, but none of those are needs for care and support. That is not what this regime is about. Those needs, universal needs, are met in other ways. We say, now, the court below, as at least as I read the judgment, focused on whether holidays, recreational activities were needs for care and support. Don't believe she went on to consider the issue of whether they were eligible needs. We say they are neither. We say they're in the second concentric circle, but not the smaller third and fourth.
Sorry, can you just repeat that again?
Yes. Mrs. Justice Lang, in her judgment, as I read it, focused on whether holidays and recreational activities were needs for care and support, rather than whether they were eligible needs as well. We say they're neither. We say they're within the second concentric circle, but not the smaller third and fourth. They're needs, but they're not needs for care and attention.
Support.
And we say needs for care and attention concerns needs to be looked after.
You move to care and attention rather than care. I know that.
Sorry, yes, needs for care and support concerns needs to be looked after. And there's two first instance authorities. There's no Court of Appeal or Supreme Court authority on the meaning of these words.
But Lady Hale used the word looked after, you cited in paragraph 43.
Yes, that's in relation to a earlier regime, and it's quoted by Mr. Fordham QC sitting as a deputy judge in the Aburas against Suffolk case, which I was going to take you to.
Thank you.
Because he was considering the Care Act regime and drawing on dicta in relation to the earlier regimes. Now, the wording was different, as he acknowledges, but the Aburas case is tab 28, my lord. This case is, the Aburas case is slightly different to the present case. It wasn't, because you've got the immigration issue and there were human rights. It wasn't just Care Act. there are issues that were live in this case that aren't live in the present case. You've got the factual background set out at paragraph 2. Claimant was a stateless Palestinian, mental health issues, failed asylum seeker, and I think was broadly destitute. Paragraph 5, which I quote in my skeleton argument, you have the court considering what is the meaning of looked after needs in section 9. And Mr. Fordham QC, as he then was, set that out. As I say, it's in my skeleton. But his conclusion is needs for care and support means needs to be looked after. And he's derived that conclusion in part by looking at earlier case law on different statutory regimes, most notably Lady Hale's judgment in the M and Slough case. The issue in this case was whether accommodation was a looked after need. And the court concluded it was not. So it wasn't looking at holidays. So whilst the claimant in this case had a need for accommodation, as in it was necessary for sort of usual functioning, it wasn't a need for care and support. That fell within the second circle, but not the third, and necessarily, therefore also not the fourth. So accommodation is not, that was held in this case and other cases, a need for care and support. Because
just helps with the first sentence of paragraph 6.
yes,
And the distinction he's drawing there.
need for accommodation is not itself a looked after need, but the provision of accommodation may be called for so as to secure effective care and support for a looked after need.
Could one substitute holiday for accommodation in that sentence?
No, what one can't. The point is made in relation to accommodation because Section 8 of the Care Act is entitled How to Meet Needs. This is tab 4. And there's various examples of how needs can be made. See section 1. 1A says accommodation in a care home or in premises of some other type. So if an individual lives on their own, is frail, is unable to feed themselves, unable to get dressed, one way of meeting those looked after needs is by putting someone in a care home where care workers can do that. But the analogy doesn't work with a holiday. You don't go on a holiday so you can be clothed and fed. That analogy simply doesn't work. So we looked at the eligibility criteria before lunch, and they referred to nutrition, clothing, being able to make use of the home safely, maintaining a habitable home environment. Maintaining a habitable home environment presupposes that you have a home. But having a home, a need for a home, is not a care and support need. There are other regimes, like there are other regimes for activities and holiday.
How would you express the second sentence by reference to holidays? How the holiday question be expressed in those terms?
The
need for a holiday is not itself a looked after need.
Yeah.
Yes.
But you don't go.
Why can't a provision of a direct payment for a holiday be called for so as to secure effective care and support for a looked after need?
Well, what is the looked after need there? It's asserted by the claimants that the need in question is a need for holidays. It's not the case as articulated is not holidays are needed to meet other looked after needs. It is the holiday itself is a looked after need. That's the case that was put. That's the case we need to meet. And we say, no, it's not. It's similar to accommodation. It's similar to food. It's similar to clothing. It's essentially less essential than food, shelter, clothing. But it is not a looked after need. If someone is on holiday and they need to ensure that they're appropriately dressed for the weather, support for that can be provided under the Care Act. And that's the distinction that was drawn in the 3rd of March letter. Support on holiday could be a looked after need if, for example, there were the individual in question couldn't dress themselves appropriately or couldn't feed themselves. That obviously doesn't arrive this case because there is a carer, namely S, who meets those needs. But if you had someone who didn't have a mother or a family member looking after them and they used their money from other sources to go on holiday, they may need to be supported in that. So the feeding of them, if that's necessary, ensuring appropriate clothing, hygiene and so forth. That's the line drawn by the council, and we say that's the appropriate line. It accords with the first instance decisions that I'm taking you to. Now, of course, they're not binding on this court. The court may make a different decision. But we say if recreational activities, holidays, amount to looked after need, a need for care and support, there is no basis for drawing a line between those on the one hand and food, clothing, accommodation on the other. If holidays, recreational activities, provision of those are a looked after need, so is food, so is clothing. And there's no principal basis of where a line could be drawn. And if that is right, the Care Act suddenly becomes a broad welfare provision to provide clothing, food, trips here, there, holidays, but that's not what it's about. It's about looking after people. Essentially, if an individual has a health matter, the provision under the Care Act puts them in a position to the extent possible they would have been if they didn't have that problem. So a person without any mental or physical health needs goes on holiday, they don't need any assistance in wearing the right clothes and putting on Factor 50. The Care Act puts someone who doesn't have that ability in the same position. If they also choose to go on a holiday, they are to be looked after if they have eligible needs. And eligible needs would include appropriate clothing and so forth. So that's the critical line. That's the line that the council drew, and that's the line that they think reflects the case law. And it did reflect the case law up to this particular case. Now, of course, none of that's binding on this court. The court may decide that's wrong. But if you do, we say the inevitable consequence of such a decision is that food and clothing would similarly be needs for care and support.
So if there was a third-party carer involved here,
Yes.
would paying for them to fly with B&K and stay, say, in Florida,
Yep.
that might be funded?
Yes. In the same way, if B&K were going to the cafe, a support worker to help them get there using public transport, order the food, make sure they don't choke, etc., would be a looked after need. Yes, that's precisely our point.
And the
So-
critical... No, you carry on. No.
Well, the follow-up question I was going to ask was that you would pay for a third-party carer to go fly to Florida and have accommodation there, and you're willing to fund the mother if she wanted it, but you're not willing to. But you're not willing to continue the payments, which would in part.
Because on the case law prior to this, we were not empowered to do so. The council has got to try to act lawfully. It may think, well, and its understanding of the law is care and support needs means looked after needs, and that means it can provide certain things, but not certain other things. And the March letter sets that out clearly. Now, that understanding, the court may say, it is wrong. I would say it accords with all the case law that preceded this.
Do you accept the approach that Mr. Fordham proposed paragraph 9 of his judgment in the Aburus case? About how the Care Act is structured?
Yes, my lord, and that I would accept that, and I would say that's what we did.
I haven't heard much about section 1 of the Act, which Milady pointed out wasn't in the bundle of authorities.
Yes.
But is cited by the judge at paragraph on page 63 of the judgment.
Yes, I have.
And you have it, do you?
Yes.
I wonder whether we could have that.
Of course, my lord.
Usher. And because integral to the structure which Mr. Fordham, as he then was, describes in Roman 2 is section of 9 factors in section 1 subsection 2.
Yes.
The concept of well-being.
Yes, and as I understand it, it's never been articulated that there is a breach of our approach to section 1. That's our approach on section 1. I don't think that, if one looks at the claim, that was articulated.
I read it as being quite important in the judge. I may be wrong in the judge's analysis.
Yes.
Example at paragraph 103 of her judgment on page 74.
Paragraph
103 on page conclusion.
103. Yes.
On ground 1.
But the point, having a holiday improves everyone's well-being, unless it's a disaster. And of course, being provided with food improves someone's well-being. The fact that something provided assists in someone's well-being does not mean it is a need for care and support. Because of course, food, clothing, housing are absolutely critical to someone's well-being. But section 9 does not provide that they are care and support needs.
Well, what Mr. Fordham talks about here or somewhere is the flexibility which the way this is structured, the non-eligibility provisions are structured. So why wouldn't you have the power to pay for holidays to meet an established need having regard to well-being?
Well, we don't have the power because we say it's not a care and support. It's not a need for care and support. It doesn't need to be an eligible need if it's an issue of power. It's whether it is a need for care and support. And we say the provision of holidays is not a need for care and support, and the way provision of food is not a need for care and support, because neither of them are looking after an individual.
That's why I come back to the second sentence of paragraph 6, and I wonder whether you're right about saying that that doesn't carry over to holidays.
Well, but that has never been the argument that's articulated. The argument is holidays per se are a need for care and support. But
all right. Well,
yeah.
Yes.
Before you move on, Mr. Sharland,
Yes, my lord.
picking up on the questions asked by my Lord Justice Phillips, you accept that if it hadn't been the mother, paying for third-party flight and accommodation would be covered? And if the mother wanted it, it could also be covered. What I'd like to know, please, are the provisions under the Act which you say would cover it.
Well, let's deal with the carer first.
When you say the carer, you mean a third party?
A third-party carer.
Yeah.
Well, the provisions are Section 9 and 18, because the carer there would be fulfilling a looked after need.
Right.
In relation to the mother, I haven't. To be honest, I don't know the position as to the basis of paying for her to go to Florida to look after the children. I took you to an extract in the skeleton argument where we explained that generally you're not permitted to pay family members to care, but there is an exception where it's necessary. And in the skeleton argument, we indicated that we were prepared to reach that conclusion. So the provision of care by the mother, we said that we would pay for there. Now, that's slightly different to paying for the flight on holiday, which I hadn't considered before the question was asked, and I'm not sure what the answer to that is at the moment. I'm not sure what the power to pay the mother in those circumstances would be.
That'd be part of the care she was providing, which you're willing to pay for. It will be part of the care she's providing.
That may well be so, my lord. I'm not saying it's not, but it's not something. Given that the mother has never expressed a willingness to be paid for the care, this is sort of a little academic.
Well, she certainly would like to have the £6,000
Yes.
to go with her sons to Florida.
Yeah.
And I suspect she wouldn't terribly mind whether that was a payment to her sons or to her, or part of it to her.
Well,
Seems slightly dancing on the head of a pin.
but no. Either we have a power to do something or we don't. We've said, look, we've got a power to pay you, the mother, for caring for your children, because although there's a general prohibition, we think an exception applies. So we're trying to act lawfully, my lord. So it's not dancing on the head of a pin, it's trying to act lawfully. Now,
You can say, so you've been paying you this money under on the wrong basis. We were paying it to you as on the basis that it's a care need. In fact, we'll pay it to the carer.
Well, that's what we've offered to do, my lord.
Well,
And it's been declined. There's been no engagement in that offer. What is said is, no, you should pay for holidays because their needs for care and support. And that's what this litigation is about. Notwithstanding that we made clear that we were willing to pay her for caring for her children.
So are you willing to pay the 6,000?
Well, I've got no idea on what basis that the cost of care would be paid for. So I don't know what the figure is. I'm not trying to be unhelpful. I just don't know. It may be less than 6,000. It may be more than 6,000. I've got simply no idea.
Are you willing to pay it?
Well, that's what we say in the skeleton. Yes.
Just show us where precisely you say it in the skeleton, and also I think where this appears in where the offer's made in the documents. Reference to a chronology. You haven't got the document itself.
33 to 34. Page A147 of the core bundle.
Well, there you're reciting the provisions of Section 31 and 32 of the Care Act.
Paragraph 33 and 34, we refer to the Care and Support (Direct Payments Regulations 2014, which details a general prohibition on the payment of family members to provide care within the same household. However, the regulations do permit an exception to the prohibition where it is necessary to pay the relative. Defenders signalled its willingness to apply the exception to the claimant. Paying the claimant's mother would be considered necessary given the claimant's difficulty trusting other carers. However, to date, the claimant's mother has not sought to pursue being paid for the care she provides for her son. Now, I think I was asked whether that's been referred to previously. It's definitely not in the documents before this court. I don't know whether that offer was made previously. I think it was, but I can't point to where it was. But in any event, it's made clearly there.
So you can't help us when you first signalled your willingness.
Well, no, my lord. But that's a different payment.
Yeah.
I think my learned friend and I agree that is different to payment for holidays. And that either we have the power or duty to pay for holidays, or we don't. That is not contingent on whether we pay S for the care she is provided. They're separate. The reason I raised that is the understandable concern of the court about the treatment of this family and their needs and so forth. And I think it's important to bear in mind that councils are often portrayed as the bad guy, but they have limited resources and they have limited statutory duties and powers. And what we're trying to do is act lawfully.
This court's very aware of the very severe restrictions on local authority budgets.
So if we are right and we don't, and the holidays are not needs for care and support, we cannot provide them under Section 18 or Section 19. What we can do, separately from all of that, is pay the mother for the care given, and we've flagged that up in our skeleton argument, in an open document that I'm referring the court to. So what we're trying to do is act lawfully. You may tell us that we've got it wrong. We don't think we have, and what we have done, we say, accords with both the legislative scheme and the relevant authorities, albeit they're only first instance. That is... I felt there was sort of a suggestion that the council was being irrational in its approach, saying, you can't have money for this, but you can have money for that, and it would probably be about the same money. But that's not us being difficult, it's us trying to fulfil our legal obligations, and with the guidance of the court. The payment to the mother for care is completely separate from the issue about whether we have a duty or power to pay for holidays. And I'm not suggesting otherwise, and I think that's clearly agreed.
So for my part, I understand that.
Yeah.
It's just that the slight practical reality here, when may be that at the end of the day, it matters not in terms of the finances.
Yes, but that, we can't just say, well, it doesn't really make any difference as a matter of finance. We have to try as well as possible to comply with our statutory duties.
Well, I don't want to... I see that it's not the key. But it was open to you in March and November 2020 to have said, well, we can't pay you this money, but we could pay you this or a similar sum by this different route. And that might well have meant we didn't end up this litigation.
Well, I don't know when we made that offer. I do know we made that offer in the skeleton argument below. When that skeleton argument was received, the claimants did not say, oh, well, we can bring an end to the litigation. It carried on. So I don't think I can take it any further.
No,
it may have been raised at an earlier stage. I simply don't know. I haven't seen any document where it was, but I've been looking at sort of, narrower documents for the two sort of points that are before the court, and payment to carers is not part of the grounds on which I got permission to appeal on. It's background, and that's why I raised it.
Right. So where do we go now, Mr.
Well, I've taken you to the Aburas case, and can I also take you to the GS case, which is tab 29? Maybe it's not.
No, that 29 is doing. We've been there already.
I've given you the wrong reference. Tab 22, my lord.
Thank you.
I have a page number because I'm trying to work electronically.
Pardon, my
Could I
lord.
have a page number?
Of the whole bundle?
Yeah.
397, I
Thank
understand, my lord. And you'll see in paragraph 1 of the judgment of Mr. Peter Marquand, paragraph 1 sets out the summary. This is a challenge by way of judicial review of the defendant's decision, 26th of October. Claimant is an adult and a Swiss national, suffers from physical and mental health problems. Challenges the defendant's decision following assessment under the Care Act that she did not have a need for care and support, in particular a need for accommodation. So here the assessment is challenged, which is what we say should have happened in this case. Defendant's position is that the need for accommodation is not a need for care and support within the Care Act 2014. There's no power under statute to provide such a need. So again, this case was considering what is a care and support, a need for care and support. And broadly, the court adopts the same approach as Mr. Fordham QC in the Aburas case, broadly for similar reasons. Paragraph 21 deals with the issue of the meaning of care and support. And like the Aburas case, Baroness Hale's judgment in the Slough case is cited in support of the proposition that accommodation is not a care and support need. Paragraph 24, the judge relies on Lord Neuberger's judgment in the Slough case, which wasn't referred to by Mr. Fordham QC. Lord Neuberger in that case is talking about the phrase care and attention, but both first instance judges say we can derive support for the meaning for need, support and care needs. As for care and attention, whilst going right to caution against the risk of reformulating the statutory language, it appears to me that Lady Justice Hale was right to say in this context the expression means looked after, and that ordinary housing is not in itself care and attention. And citation of the Wahid case. I do not consider that care and attention can extend to accommodation, food, or money alone, or indeed together without more. As a matter of ordinary language, care and attention does not of itself involve the mere provision of physical things, even things that are important as a roof over the head, cash, or subsistence. Of course, if a person has no home or money, or even more, if he has no access to food, he may soon become in need of care and attention, but as I would explain, that is beside the point. So, under the old statutory regime, a line was drawn between looked after needs and other needs, accommodation, food, money, which were not needs for care and attention. And both judges in these judgments say, well, that's very helpful, and I think a similar analysis applies to Section 9 of the Care Act. And whilst there was no discussion in this case of holidays or recreational activities, we say they are akin to accommodation, food, etc., clothing, in the sense that they are not looked after needs, they are needs. And there are other statutory regimes, universal benefits, that provide for food, accommodation, activities, etc., etc. And that is the critical point. You're either with me on this or you're not. If you're with me, recreational activities and holidays are not a need for care and support, and then there's no power or duty under Section 18 or Section 19. We say the judges in these two cases were right to draw the analogy with the dicta in the M and Slough case, and that is a correct approach. And if holidays fall on the other side of the line, so does food and clothing, accommodation and so forth. But universal needs, food, clothing, activities, holidays are funded by benefits, the employment and support allowance. Those benefits do not provide for looked after needs. That's where the Care Act comes in. Then at paragraph 45, I address the judge's reasoning on this point. And the first point she refers to is statutory guidance. That's paragraph so I had this 113, 14 and 17. Statutory guidance is not a basis for interpreting earlier legislation. It's not a legitimate task, a legitimate tool for interpretation. I hope that's not a controversial proposition. The statutory guidance doesn't really take us anywhere. The statutory guidance relied upon was not statutory guidance in relation to individuals such as B and G, but it was in relation to carers. And the approach on carers is different because the entitlement to support for carers arises on a different basis, or at least the approach to eligible needs is different. Second provision that the court relied upon was Section 8 of the Care Act, but Section 8 just sets out the way, doesn't define needs for care and support. Section 8, which is tab 4, is how needs can be met. And now, one can meet needs in various ways, and we looked at Section 8 a minute ago, and one way of meeting needs is placement in a care home. Another way of meeting needs, for example, say someone has Parkinson's and they're unable to move, unable to walk because of the impact of the disease on their muscles. That individual's needs could be met by the provision of a hoist. So aids there. And there are various ways that the needs can be met, but Section 8 doesn't tell you the meaning of needs for care and support. The third matter relied upon by the learned judge was how she described the authoritative textbook Clements on Community Care Law. That's at tab 33 of the bundle. And all the authors of that textbook say is it's arguable that assessments under the Care Act should identify a need for an annual holiday. That's paragraph 8.91. But they're not articulating a view that that is the case, it's just that it's arguable. we say that is inconsistent with the relevant case law. Next matter relied upon by the judge is an old authority called Hargreaves, which we have in the bundle at tab 11, my lord and my lady. We say that doesn't assist because the particular provision being looked at there made express reference to holidays. I deal with this at paragraph 51 of my skeleton. That concerns section 2.1 of the Chronically Sick and Disabled Persons Act. In my skeleton there's a typo. I think I say it's 21.1. It's actually 2 subsection 1 where there is express reference to costs of holidays. So that doesn't assist. And the final matter that the court relied upon was the Aburas decision, which I've already taken you to, and we say doesn't support the case. It supports our case. At one point, I took you to section 8, which identifies how needs can be met, and I said that doesn't tell you what are needs for care and support. That was my assertion, but you'll see at paragraph 47 that was what the court said in the GS case at paragraph 28, Roman 2. So that is essentially our case on the meaning of needs for care and support in section 9. And if you're with me on that, and that holidays are not needs for care and support, and recreational activities are not needs for care and support, that means there's no duty under section 18, but equally there's no power under section 19, because section 19 only applies to needs for care and support. If you're against me on the interpretation of needs and care and support, and you say that holidays may amount to needs for care and support, we then need to consider whether they're eligible needs, because that will determine whether we have a duty or a power to provide them. And I address that at paragraphs 53 to 54 of the skeleton argument. And we say, even if we're wrong on that, they are not eligible needs. And I think it's worth turning up tab 6 and look at the eligibility criteria again, so I can develop this additional point. So that's tab 6. And we're not looking at the specified outcomes here. We're first looking at section regulation 2.1, paragraph 1. An adult's needs for care and support meet the eligibility criteria if those needs arise from or are related to the physical or mental impairment or illness. And we say the need for a holiday, need for recreational activities like the need for food and clothing does not arise or relate to physical or mental impairments. They're universal needs. And therefore, they are not, even if they are needs for care and support, they are not eligible needs, and there is no duty to provide them. And that is the point I make at paragraph 53 of my skeleton argument. And I make the point that the state does not generally provide funds for holidays, recreational activities for persons who can't afford them. A level of benefit is provided, and that can be used for such matters if the individuals choose to and if they have sufficient money. But generally, the state does not fund holidays. Paragraph 54, sort of making this distinction clear. By contrast, the need for care and support whilst on holiday, for example, from a carer who assists the individual, make sure they remain safe by ensuring they wear outfits appropriate to the weather, would arise from or be related to the respondent's physical or mental impairment or illness. The appellant made, the council made clear that it would meet such needs, see the letter of the 3rd of March. However, this is not what the respondents are seeking. The respondent's carer meets all such needs, whether the respondent is in the UK or on holiday abroad. Paragraph 55, I would seek to draw some assistance from the statutory guidance, but generally, given my submission that statutory guidance is not a good tool, relevant tool for interpretation of statutory provisions, don't think I need to develop that point. We say, for the above reasons, it's clear that the court erred when it concluded that the appellant had a duty to provide holidays and recreational activities pursuant to Section 18 of the Care Act 2014. That just leaves ground 3, and I don't really need to say anything further on that, because ground 3 turns on whether, if you're against me that these needs are needs for care and support, whether they are eligible needs, and we say they are not. I've already articulated that reason, and therefore there is no power under Section 19 to provide them. I think unless I can assist the court any further, those are my submissions. I actually managed to keep to my time estimate.
Thank you very much.
Thank you very much.
We're very grateful to you. Thank you very much, Mr. Charlotte. Yes, now, Mr. Wolfe.
Can I just rearrange the furniture for a moment?
Of course.
Just give us a moment, Mr. Wolfe.
Oh, sorry, can I have the other one? Sorry.
You want the other one?
Yeah, sorry, that one's on there.
Okay.
Thank you very much. Thank you very much.
Now, Mr. Wolfe, I don't want you to feel in any way constrained by time. This is an important point.
I'm grateful.
And if the time estimate has turns out to be an underestimate, it certainly won't be the fault of council. So take whatever time you need.
Oh, I'm grateful.
And it would be good if you could keep an eye on the clock and let us know if you feel.
I suspect I'll finish by 4 with a fair wind.
Well, okay. But don't feel under any pressure to at all.
My Lord, my Lord and Lady, can I start, please, by some general case law in relation to multi-stage decision-making processes of the kind we have here. This, of course, is primarily referable to Mr. Sharland's ground 1, but it does set the context for the overall picture, if I may. Mr. Sharland referred you to a decision called Irena's Child. You have that in tab 17 of the legal materials file. I think that's page 228, if that assists.
It is.
Mr. Wolfe, we know you're going to keep an eye on the clock, but the most important thing, as my Lord has said, is that you are able to say all you want to say. Don't rush it. What I'm trying to say is don't speak quickly, because as we were making notes when Mr. Sharland was speaking, we're doing the same with you.
I'm grateful, my lady.
All right.
If I go too quickly, you please tell me.
I will do.
I know you will. My lady Mills, the reason I show you this is to distinguish between these kind of situations and the Boddington type case, where Boddington, for example, was concerned with the making of a statutory instrument, a one-off legal act. Irena's Child, just to get the context, can I just draw your attention to the paragraphs that set the scene? Paragraph 12, this is about an adult social care assessment and a challenge to that assessment. You see that mentioned in 12. I'm not concerned with the detail of that. What you then see at 21 is that there was a judicial review application of that assessment, which itself provoked a further assessment. The challenge to that assessment failed on its legal merits. I am concerned with what the court then said, paragraphs 71 and 72, or rather what Lady Justice Hallett said, 71 and 72. I won't take you through the whole of those paragraphs.
Would you want us to read? Would you like us to read the paragraphs?
You could. The critical bit from my point of view is around lines 4 and 5 in paragraph 72.
All right, well, just give us a moment. An assessment prepared as part of an ongoing process.
This is not a final determination of an entitlement.
Yeah.
If I then show you, if I may...
Sorry, I haven't finished reading.
I'm sorry, lady. Burkitt, if I may, which is in tab 15, page 150, I think. This aspect of Burkitt, and I start, if I may, at paragraphs 38 and 39, concerns the multi-stage process of the grant of a planning permission, where there is very often a resolution to grant planning permission, and then after various intermediate steps, the planning permission is granted. And the question was whether the claimant could, and if she could, whether she was required to challenge the resolution, stage 1. On the first of those, paragraph 38, line 3, in a context where there is a statutory procedure involving preliminary decisions leading to a final decision affecting legal rights, judicial review may lie against a preliminary decision. So you can challenge the resolution. And as we saw in Irena's child, you can challenge a care assessment.
Well, and to go on, last sentence, it does not follow from the fact that she could have challenged the resolution that she could not have waited
Exactly, that's
and
where
then
we're going.
challenged the grant.
That's what we're going, my lord.
Oh, sorry.
So, just to give you the route through that conclusion, paragraph 39, six lines down towards the end of the line, until the actual grant of planning permission, the resolution has no legal effect. And that picks up what I showed you in Irena's child, and you saw it on the facts here. It wasn't until the 12th of November that we actually got something to the claimant saying your payments will cease. And the rationale for what the House of Lords said there, I won't take you through the detail, but just to give you the signpost, is at paragraph 45, there's a first, and then 46, and then I do want to dip slightly into 50, which is thirdly, the last 4 lines of paragraph 50. These considerations reinforce the view that it's unreasonable to require an applicant to apply for judicial review when the resolution may never take effect. And that's exactly the position here. The assessment in October 2019 not only did not determine legal rights, it was not final in the sense contemplated there.
You're probably going to develop this, and if you are, I'm not taking you out. But I would like you to explain why you say it wasn't final. But
Absolutely,
do it when you're
absolutely,
going
my lady, absolutely. I will. The final reference within the Burkitt speech of Lord Steyne is in paragraph 31, and it's an oft quoted sentence 4 lines down in paragraph 31. In public law, the emphasis should be on substance rather than form. And he then explains how, if necessary, time could have been extended to deal with the particular issue there. We say exactly the same point applies here. The court is not concerned to focus on that technicality. The court's concerned with substance. Put that bundle down for now,
Yes.
if I may. My reference to the facts and the chronology, I think I can do mostly by reference to the judge's judgment, which I hope will make for easier note-taking. Just one departure from that to start with. The judge at paragraph 33 referred to the July 2018, B's 2018 support plan, and within that you have the document. Oh, no, you don't have the document. Sorry, you don't have the document of that one. What she sets out, though, in the passage running over the page, the foot of the page is old heading, meeting the customer's needs.
Time away from family.
And what are the person's outcomes? Important word. That's the question. And then over the page, paras 8 and 9. 8, to be supported to have respite away from the family home. And then 9, to support to access membership of various things.
Yeah.
So this is the point at which the local authority is assessing those types of things as being, I can put it this way, in scope. This is before they change their approach. And that led to, as the court knows, payments in respect of both of those needs for care and support, as they were seen at the time, including the cost of the trips. It was the whole cost of each of those activities. That's what the payments were potentially in relation to. Paragraph 26 of the judgment. Sorry, that can't be right. Paragraph 36, I'm sorry, of the judgment. The judge quotes from a July 2019 letter from a community nurse, which was part of the assessment process. The letter is several pages. The extracts you have are all from supplementary bundle page 20. You've got the whole letter. That letter, including those paragraphs, address a point my Lord Justice Phillips was canvassing this morning, which is the way in which, for these individuals, provision away from home with their mother and access to the facilities of the kind we are talking about are absolutely linked to their particular disabilities. I'll come back to that, if I may, when I come to deal with Mr. Sharland's ground 2. What the judge then records, and this is paragraph 132 of the judgment, is the change in the council's legal approach. 132, she says, and this is manifest, the council started to adopt a restrictive approach. And what we then see, and she refers to this elsewhere, is that that was a restrictive approach of law. They took the view, as a matter of law, that they could not fund this type of provision. And the fact that their approach was driven by that approach of law is key to when the court comes to look at Mr. Sharland's grounds 2 and 3. We then have paragraph 41 of the judgment and paragraph 47 of the judgment, they are the pair, the October 2019 assessment documents. Assessments under or pursuant to this new restrictive approach. What you see in paragraph 40 describes to some extent the process. It tells us that these were not sent to the tells us the claimant's mother's evidence that these were not sent to her until November 2020. You've seen that that is not disputed. So these did not come until, as it were, all of this drew to a focus in November 2020. And then the next sentence, the judge's judgment deals with these documents in the slightly reverse order, so I'm just taking it slightly slowly. It produced an email dated 2nd of January attaching the draft care and support plans and informing the advocate, Kate Chapman, that the indicative personal budgets. That is a reference, slightly unhelpfully in the way the judge's judgment flows, back to what we see at paragraphs 37 and following.
Sorry, just make that point again. What is reference?
I've
got the point about November 2020. I got that right. So these assessments that we've been looking at were not, from October 2019, were not sent to SQ or the claimants till November 2020.
Exactly. But there's another document, which I'm going to show you in a second, which was sent in January 2020, right, which is the document the judge draws from at paragraphs 37, 38 and 39. A draft support plan. This is where I come to answer my lady's question. So what the claimants and their advocate got was a draft support plan.
This is now in January of 2020.
Exactly. Mm-hmm. And if you look at the text of it, in paragraph 38 and then running into 39, 38 is still, as you see the bit running over the page, mentioning important for him to go on family holidays, so that is still in play in the text in that draft document. And then in 39, middle of the quote, slightly below the quote, the bold text, so the question, making use of necessary facilities or services in the local community, including. Note just in passing that that suffers from the same missing comma that the court was focusing on previously. So focusing inappropriately on only local, if I can put it that way, and mention of the sorts of facilities in the, albeit only at this point, local community, which were in contemplation. And then the last bit of the quote, just above paragraph 40, direct payment to be discussed. So this is a draft plan coming from an assessment which couldn't be more tentative and certainly can't be taken as closing off consideration on holidays or access to those various support facilities.
I know you're going to looking at these through the judgment. Do we have that document and or the letter which was accompanying it?
You don't here, but I'm sure it's in the bundle below if you wanted it.
Well, for my part, I'd like to see it, I think. If it's, because it was clearly
So
material.
this is the 2nd of January email, I think that's what you'd be looking for.
Is it an email?
Well, I think it says, yes, so paragraph 40, it produced an email dated 2 January 2020 attaching a draft care plan. That's why I say email. The very foot of page 50 of your bundle.
All right. So just so I'm clear, the document referred to in 40 is the document summarised in 39.
That's my understanding of it.
Okay. Well, for my part, I'd like to see the email and the attachment.
I'm sure we can do that.
And it's repeated, is it, when we get to KG?
We actually don't have KG's version of the document. We have a reference to, so paragraph 40 says the draft care and support plans, but the judge has only extracted from one.
Thank you.
Obviously we can. You then have in the sequence the 3rd of March letter, Judge paragraph 53. And in terms of, as it were, final implementation of these various things that are in play, the high point, and I think my Lord Justice Phillips drew attention to this, paragraph 53 within the quote, the top of page 54, Suffolk County Council is no longer including holiday travel and accommodation costs in personal budgets. That's the high point of it being, if you like, a decision. But we haven't yet got, we, K and B, haven't yet got to the point where we've got any kind of implementation of that kind of decision. This at best is a signpost of their new approach.
Well, if they had made a determination, there was a statutory obligation on them under section 13, subsection 2, to give the adult concerned a written record of the determination and the reasons for it. So on the assumption that they're complying with their statutory duties, they haven't done that. And they don't.
Certainly not in this letter.
And they don't do it till the 12th of November, and possibly not even then. Not sure they gave any reasons.
My Lord, if it assists, we accept that although it's dated October 2019, there's no evidence that it was provided before November 2020, and it's at that point that information was given to the individuals. And we say that, but we're not suggesting it was given before.
But in terms of 3 March, when my Lord's point is obviously applicable to 3 March, it isn't a notification of a determination. And my further characterisation is it's at best a signpost of a future way of behaving. And the reason the judge, I think, focuses on it is that the rest of that paragraph then signposts the way of proceeding. And it's the last sentence, really, which is the kind of indicator. The council can only use the ASC budget or ACS budget to meet the council's statutory function. So that is the focus of the restrictive approach a direction of law which the council has adopted. And it's critical to understand the way in which that self-direction of law works, because, as the judge says, it then informed their assessment process, or had informed their assessment process, so as to preclude the holiday and other payments. And that absolutely matters when I come to deal with ground 2, because we are not for a second saying that those kinds of things are always needs for care and support, let alone eligible needs for care and support, just that they can be. They can be. And the council's big error, and this is picked up in ground 2, I'll come to it shortly, is to preclude the possibility of that. It's Mr. Sharland's concentric circles and the apparently hard, hermetically sealed boundaries he draws between each of his rings. And where he then puts things, he would have it as a matter of law in those rings. That is the council's error, and that's what the judge, quite properly, we say, focused upon. Paragraph 54 of the judgment, the judge summarises the process that was then taking place. The process of finalising the revised support plans continued. She summarises that. This is an ongoing process coming, next paragraph, to the legal resolution. Then paragraph 55, the 12th of November letter, I am writing this letter to confirm the outcome of the support planning process. That is where the legal error, which may have been visible earlier, crystallises. See Irena's child, see Burkitt. We could, if we'd known about it, have challenged earlier decisions such as the eligibility decision, but we were not required to. And that's the critical thing. And the outcome of the support planning process, in the paragraph quoted at the foot of page 55, is this means that Suffolk County Council will. And this is where we see, this is where we are told that they are stopping the payments.
Will be ending.
Yes. Whatever hints we've had before, whatever, with the benefit of hindsight, we can now infer from documents. Just pausing for a second on that point. My Lord, Justice Baker asked some very pertinent questions of Mr. Sharland about where on the face of this assessment do we see assessment of ineligible needs? Nowhere. So his submission, his authority's submission, effectively, is we were expected to infer from silence on certain points that absolutely fundamental on his case decisions had been made. We say that can't possibly be right. This is the first point at which we get a determination of our legal rights.
Is this the first direct letter to the claimants?
To the claimants. Well, in to anybody, because...
But specifically to the claimants,
yes.
Because there have been backwards and forwards.
Yeah. But it says even if you broaden the point, sorry, I'm not being picky, even if you said any letter, there hasn't been a previous letter or previous document, any of the players here, that says we are stopping your entitlement for these various things, let alone explaining why, to pick up my Lord's further point. The other thing, just in terms of the way the judge dealt with it, let me just signpost this. Paragraphs 61 and 69, the judge extracts text from draft care assessments that are after the decision being challenged, but before the court hearing, indeed some 10 months later, September 2021. So by the time the judge is looking at this, she already knows that fresh assessments are underway. That is relevant when we come to look at the way in which she contemplates her order. And it absolutely picks up the continuing nature of this process, this kind of process. And it picks up the point my Lord Justice Phillips was canvassing with Mr. Sharland about public authorities, as it were, reviewing once they realise there's an illegality. So for her, just to jump ahead to her order, to order a fresh assessment in the light of the law as she had stated it, was entirely consistent with what was happening, in a sense, in any event. So just then go back to the foothills of ground one, what the claimants challenged, they challenged, and on my submission they were completely entitled to challenge, the 12th of November letters. Even if they could have challenged earlier, or asked for an extension of time to challenge something they'd only just been aware of, there is no requirement for them to do so. Nor, in this context of continuing or multi-stage decision-making, do any of the principles that Mr. Sharland identified about decisions being unchallenged unless challenged apply. That is simply not applicable in this context. And you have Court of Appeal and House of Lords, authority dealing with these kinds of processes. Look then at how the judge dealt with it, because she is the subject of the criticism. The statement of facts and grounds, as you've seen, challenged the 12th of November decisions, but made very clear, as my Lord Justice Baker canvassed Mr. Sharland, that the complaint was of the council's legal approach, including in the assessment. That is absolutely impeccable. The council's summary grounds of resistance, and here I need the court bundle, you have the summary grounds of resistance at page 158. The council's response on grounds 1, 5 and 7, this is on page 159 of your bundle, is that those grounds are out of time. But if we go over the page, the out of timeness, this is paragraph 6, is by reference to the 3rd of March letter. No mention is made of the point which emerges later and in the submissions before this court of this having been settled in October 2019. That explains the approach taken by Mr. Justice Mostyn, page 151. He was dealing with a response which says, you're too late, you should have challenged in March. And he dealt with that, we say, absolutely sufficiently. He took the view, we say entirely rightly, that the 12th of November decision rolled forward anything that had been decided in March. And he took the view, we say entirely rightly, that if necessary, an extension of time should be given. You've heard my submissions now on why no extension of time would have been required, because Burkitt, Irena's child, jurisprudence. But his approach was impeccable. And he clearly signposted, even if he didn't actually make, an order that would deal with any wrinkle in relation to that matter. The judge, when she comes to the substantive hearing, was then entirely right, we say, to focus on the legal approach taken by the council in the totality of that process to see whether it undermined the 12th of November decisions. That is what the statement of facts and grounds had invited. And she cannot be criticised for that. The argument that we should have challenged the care assessments not only fails on the law, see Burkitt, but is also inconsistent with the way the council responded to the claim. The judge's approach then, we say again impeccably, was to analyse the legal correctness or otherwise of the restrictive approach she had identified the council as having taken. And she refers to this, if I can ask you to turn to paragraphs 132 and following of her judgment. 132, she mentions the restrictive approach. And then 135, she says this, and the point is not challenged. In my view, the claimant's care eligibility assessments were deliberately drafted so as to reflect the council's restrictive stance on eligible needs, with the focus on any need for care and the exclusion of financial support for goods and facilities, in this case the cost of assessing recreational facilities. That was her finding, not challenged. The council says she shouldn't have been asking the question, but they don't challenge her conclusion. So this was an operative legal approach by the local authority. Her conclusion then on that at 142 by tailoring the assessment in this way to accord with the council's restrictive reading, ... And then the last sentence, consequently, Miss Eden wrote to the claimants on the 12th of November 2020, terminating all direct payments. So she quite properly links the council's restrictive approach and its, as she had found it, legal error, causatively back to those that decision or those decisions. And insofar as she needs to, she says at 143, in my judgment, the council's erroneous interpretation of its powers under the Care Act tainted the eligibility assessments by leading to a misguided exclusion of aspects of the claimant's needs. The council then failed to consider whether financial support should be offered to meet these needs. Therefore, the council cannot rely on the eligibility assessments to avoid liability under Ground 1. She deals with that point insofar as she needs to. And just to put that back into the context of cases like Burkitt and Irena's Child, when one challenges a planning permission, very often the flawed reasoning is seen in the resolution of some months previously, which you could have challenged. So implicitly, when the court quashes the planning permission, as per Burkitt, it is casting doubt on the legal correctness of the earlier resolution. Irena's Child, exactly the same logic with care assessments and care plans. So none of that is in any way problematic in terms of the way the judge dealt with it and in terms of how she dealt with the way the case had emerged before her.
Are you going to say anything about the order?
I am. I was just coming to that. My lord's ahead of me. The order is an oddity. I think you've heard explanation of how it came about. The judge's judgment does not specifically refer, she does not specifically in her conclusions say anything, as it were, directly negative about the 3rd of March letter. She refers to the council's unlawful approach, and she obliquely refers to the eligibility assessments, just shown you that, and she directly refers to the 12th of November decisions.
So how do you invite us? What are you going to do about that?
The draft order, I'm agreeing with Mr. Charland. The draft order was drawn up between council and sent to the judge for her approval, and she approved it. So
Yes.
obviously she didn't have to approve the draft that had been sent to her. She exercised her judicial discretion to do so. So I have to be slightly careful what I say.
And it was drafted by two.
It was drafted by the two junior
two
counsels.
extremely experienced junior counsel.
Exactly. That said, and without wishing to be critical of any of those players, as it were, looking at the components of it,
I've been in Miss Rowland's position at this point. Sometimes leading counsel moves slightly to the right.
Looking at the components of it, if I may, page 34 in the core bundle.
Yes. 34. Yeah. A34.
Claim for judicial review is allowed. That's uncontroversial. Miss out paragraph 2 for the moment. It is declared that the council has the power as a matter of law to provide financial support for recreational activities. That is her legal conclusion, and you've seen where that comes from. That is actually almost picked straight from the judgment. And it's important to then understand the council's appeal to this court against it, because their appeal is, as a matter of law, they don't have the power to do those things. That matters when I come to ground 2 in a moment. Paragraph 4, the defendant shall by 31 January 2022 prepare a fresh assessment. In one sense, all she was actually doing was giving a time scale and a certainty to what, as you've seen a moment ago, the council was doing anyway, as they've got draft plans in contemplation, or draft assessments in contemplation. And that would merely have been doing what my Lord Justice Phillips was contemplating earlier on, which was getting a house in order in the light of a new understanding of the law. The outlier, if you like, is the quashing of the 3rd March decision. And I accept, and with hindsight, maybe we should have introduced a cross appeal to suggest to this court that it substitute an order to the effect of quashing either the eligibility assessments, October 2019, or more particularly the 12th of November letters. But in my submission, that would actually have gained nobody anything, because we know in substance, in public law, substance over form is what matters. We know in substance what has been decided here, and it matters not that the 3rd of March decision has been quashed, because leaving that order in place would deliver today, as it would have delivered then, albeit that the dates have passed, the necessary result here, which is a lawful fresh assessment based upon a proper understanding of the law. So I don't think I can do better in without embarrassing anybody in
No,
taking
just
that.
give me a moment. Okay. Thank you very much. Yes, where do we go from here?
My lords, my lady, I think that's all I've got to say on ground 1. Apart from a possible wrinkle in relation to the order, we say the judge's approach, the claimant's approach, and the judge's approach was impeccable. We then go on to grounds 2 and 3, come what may.
Yes.
That way I don't go back over that ground. Just to then go back to the paragraph I was mentioning a moment ago, which was the provenance of that declaration. Para 126 of the judgment is the judge's conclusion on the council's error of law. And it's important to understand where we start from here. I conclude that the council did err in law in concluding that it had no power as a matter of law to provide financial support for recreational activities and holidays under Section 18.
Section 18.
Section CA 2014.
Yeah.
So no mention of. So we get Section 19 elsewhere.
Yeah.
Before you, if that's your
Yes.
concern.
That's why I said.
That's in another ground. But her conclusion on that is essentially parasitic to what she said here. You'll see that in a moment. But
Yeah.
no power as a matter of law Now, that is significant because that's two things. First of all, that's consistent with the council's approach to these assessments, which is to enter the assessment process thinking it had no power and therefore not inquiring of those potential needs and the support to meet them. Entirely consistent with that, faithful to the council's position, Mr. Sharland has quite properly defended the claim on that basis. We were right in law to take that view. But he has no doubt inadvertently at points suggested that the judge found, and we argue for something different. We are not saying that those things are necessarily and always needs for care and support, let alone eligible needs for care and support, let alone things which can and must be provided. We are not making a rule in, we are dealing with his client's rule out.
Well, I didn't understand him to be saying that, to be putting those words in your mouth. I thought his contention is it can never be.
Yes, well, absolutely. I'm happy with that. I may be doing him a disservice in him going further, but my lord is right. His proposition is they can never be, and that's a pithy way of putting what the judge has found as being his local authority's position in that paragraph.
Yep.
Can never be. And that's important. It would be ultra vires, he says, his local authority or any other local authority to make these kind of payments. And then by extension, to pick up the point my lady asked earlier on, therefore they had been acting ultra vires in all the previous years. So we are dealing with the ultra vires submission, the it can never be. That matters when we then look at Mr. Sharland's helpful concentric rings, because he erects a series of concentric rings, all of which have hard boundaries. Boundaries in relation to which this court can make adjudications of law on particular types of need or provision or whatever it may be. And we say that is simply the wrong approach. Each of these questions, is this a need for care and support? Question one, I forget which boundary that was. And is this, second question, an eligible need for care and support? Are matters of judgment for the local authority. And putting aside the accommodation cases, which we're not dealing with, and I don't propose to make detailed submissions on them, whether they're right or wrong, our simple point is there is no hard rule of law which says that financial support for respite away from your family home, call it a holiday if you want to, or the costs of accessing facilities that are not necessarily in your local community can never be a need for care and support, or never be eligible needs for care and support. The judge was absolutely right in saying that the council needed to identify where in law those restrictions come from. And there is no restriction of law of that kind.
Either on care for there being
Care
a
and
hard border, I can use that word, hard border against
support.
needs for care and support, or a hard border for eligibility.
Exactly right, exactly right. Those are matters of judgment. And the problem, the council's problem here was that it erected a hard border when it did the assessments. And that's the point the judge is making, we say entirely correctly.
Does the comma point determine the second hard border?
No, because that's only one bit of eligibility, but I'll come to that in a moment.
Okay,
in a
fine.
moment.
You're going to come on.
I'm
You're going to be a bit more
the
specific.
steps.
Thank
Yes,
you.
yes.
Right.
Mr. Sharland erects some proposition of universal needs. That is not in the law. he erects some proposition that says that if this is something that everybody needs, it can't be care and support. And he says that, for example, in relation to holidays. We all need a holiday. Therefore, it can't be care and support. We say that's a really simple example of why that submission fails, because when we look at the Jenny Thomas letter, I showed you that, judgment paragraph 36, SB20, we see that for these individuals, that is a need for care and support. Might not be for me or Mr. Sharland, but it absolutely is for these, or it's capable of being. I'm not standing here saying necessarily in, all I'm saying is not necessarily out. I don't want to overstate the position. The other introductory point, which is important to bear in mind in terms of Mr. Sharland's concentric circles, is that the eligible needs for care and support are a subset, it's a smaller circle, of the needs for care and support. So when we look, as we will in a moment, at some of the outcomes, for example, some of the restrictions which you need, or some of the hurdles you need to climb over, whatever the right metaphor is, to get to be eligible, what we have to realise is that they must necessarily, by logic of the statutory scheme, be restricting. Eligible must be a smaller category than the ineligible. So far we agree. But that also allows one to understand the approach to care and support. You can't have something that's an eligible need for care and support if it's not a need for care and support in the first place.
Yes. It's not quite ineligible, it's non-eligible, isn't it?
Well, non-eligible. Yeah.
That's the way of thinking of it. It is, yeah.
So when we then look at section 18, and you have this in the judgment, well, first of all, the court is entirely correct. The entry point to all of this has got to be section 1.
Yes.
Sets the framework, and section 1 is itself referred back to in, I didn't mean section 18, I meant section 9, I'm sorry, is then referred back to in the section 9 process.
Right. Should we do it? Can we do this in the judgment, or do you want us to go to the...
You do it in the judgment.
Because the judge does start with section
The judge
1.
starts with section 1, absolutely correctly so. Absolutely correctly so. So she starts with section 1 on page 63 of your bundle.
63.
And she makes the point that well-being is not defined.
Sorry, I'm in a... I'm,
63.
Page 63.
A63, they're all A's.
Sorry, can't... Oh. Yep.
Section 1, this whole act is about promoting well-being, and we see the way in which well-being is described but not defined in section 1-2. We then see, without spending too long on the detail, paragraph 80 of the judgment, the judge's reference to statutory guidance, so this is relevant legal material.
Yes.
Paragraph 1.5, for example, 1.1, the core purpose of adult social care and support is to help people achieve the outcomes that matter to them in their life. Paragraph 1.1. 1.5, well-being is a broad concept, and it sets out the list. She misses out the list, and so on. That is what this act is about. It's about helping people to achieve the outcomes that are important.
So what is the role of well-being in assessing the need for care and support?
We see that in one moment. We go to section 9, which is on the top of page 66.
Yeah.
And just to jump straight into answer my Lord's point, 9.4, a needs assessment must include an assessment of the impact of the adult's needs for care and support on the matters specified in section 1.2.
Right.
So there's a statutory link back to well-being. Is that the question, I think,
yes,
you're feeling towards?
It's interesting it's that way round.
So your needs for care and support include an assessment of the impact of things on well-being. And yes, they are needs, but very importantly, they are needs for care and support. And I just want to underline for a moment the word support. The judge at para 111 made the right point that support must add something. And also, if it matters, it is different from the language of predecessor legislation, which was care and attention.
How do you say that?
So
What does that mean?
big health warning about how far one can take the case law on the previous legislation in the scope, the ambit of what the needs are. And in particular, we come to see Lady Justice Hale, I think not Lady Hale at that point, in the M and Slough case referred to in some of the authorities, introducing, possibly not for the first time, this idea of a looked after need based on the language of care and attention, but much more obviously apposite to care and attention as being looked after concepts.
Did looked after has no, is not referred to in the current legislation.
I'm not sure, I haven't tracked down the earlier,
well, of
previous...
course, I come across it in children's law. A looked after child is a concept within the children. It has a very, of course, Lady Hale comes from that background. So that's got no statutory traction in this
context.
In this context.
Well, that was in the previous legislation. Yes.
Your point is that it's more akin to the concept of care and attention than care and support.
Yes. You can see why care and attention leads you to a proxy, always a risky thing, but that's the...
Is one of the themes of the 2014 reforms a greater emphasis on the autonomy of the individual?
Absolutely. Go back to the well-being.
So that would be consistent with well-being and consistent with support as opposed to attention.
Exactly.
And looked after is
a much narrower thing, potentially. And I don't need to explore the outer boundaries of that. I need to be careful how far I go. I simply need to persuade this court, I think, that the need for these kinds of trips, whether it's holiday-type trips or trips to Minsmere-type trips, is capable of being, that's all I need to get within, support in this context. And I illustrate it by saying, for these individuals.
But it would be surprising if part of the scheme of the reforms was to promote the autonomy of the individual, which is entirely what I would expect given the trends, if the consequence was to narrow the discretion of local authorities in these circumstances. On the contrary, I might expect it to broaden the discretion and to broaden the flexibility of the ability to provide. Yeah.
And what we see is a carefully crafted scheme which offers up care and support, need for care and support as the first gateway, and then narrowing that to that's the power. Section 19 power to provide things to meet care and support. Narrower than that is the duty, the Section 18 duty, only for the eligible ones.
Yes.
And that gateway into eligible ones is absolutely critical because that's the point, and we're seeing the regulations at the moment, where the question of whether your support need is linked to your mental or physical disability or whatever it may be, comes into play. And that's the safety valve, if you like. That's the safety valve. We'll see that in a second, if I may.
Could I ask you, though, I wonder whether an aspect of your submission and a difference with Mr. Sharwin is Mr. Sharwin very much focuses on the concept of the local authority paying for a third party to provide care or support. And does that, are you saying, well, actually, it doesn't have to be through a third party. The local authority can itself provide support.
Yeah, well, we'll see that when we come to Section 8, which is it can give you money.
And we see that in the statutory guidance as well, which says a local authority can promote a person's well-being in many ways.
Yes.
So there's no reason why the local authority shouldn't support the well-being of these individuals by financing once a year for them to go on holiday.
Provided that is properly considered to be support for them, which in my submission it's capable of being, and we don't need to decide whether it is. The local authority took that view for some years, and provided, step 2, it gets within the eligibility filter, which I'll come to in a second, then absolutely yes. And that includes, and I'll explain why this is the case in a moment, the cost of the trip. Not merely the cost of their mother coming with them or the cost of their mother bringing the suntan lotion or whatever it might be. It's potentially the cost of the trip, which is what, of course, happened before. And that's fundamental. We then, the eligibility criteria, just to look slightly ahead, pick up many of the aspects of well-being, unsurprisingly so, because that's the outcomes in the eligibility criteria are clearly outcomes to be supportive of the components of well-being. That's no surprise, one would expect.
Well, the leading textbook referred to by the judge indicates that it suggests that it could even be the local authority might buy somebody a caravan.
Yes. I mean, I'd be slightly careful because there may be two steps to time. I don't want to overdo the case because some of what is said in some instances is talking about Section 8 and not necessarily the care and support test in these sections we're talking about in a moment. So, but I'll come to that in a moment if I may.
Yes.
But in general terms, the proposition that a local authority has the power, potentially, and that's all I need to say, to support these things, I say is absolutely clear. Doesn't mean they always have to, but it has the power. And that's why the judge was right to reject the local authority's negative conclusion.
Before you move on, and this is me just dealing with two relatively small points. Firstly, I had looked through the 2014 Act for any reference to the looked after phrase, and I couldn't find it. There is none, I'm right on.
I'm pretty sure not.
Right.
That's not in dispute.
Right, thank you very much indeed. And the other point is this. You make the point, which the court has no difficulty understanding, that one of the purposes of the 2014 statute is to reflect the autonomy of the individual, consistent with the times we are in. Where, if anywhere, will I find that? Is in the statutory guidance, and it doesn't. You don't have to give it to me now. It can be sent overnight.
We've got the guidance, or at least some.
Yes. Yes. Can I?
You can come back to it.
I'll,
or more particularly, Miss Rowlands.
yes. I think it's a judgment somewhere, but it's a very fair point.
Yeah, well, don't take time.
No, I won't take time with it now. So can I then go on to, as it were, step two? So first of all, the proposition so far is that the need for care and support is wider than the need for care and attention. It's more focused on autonomy, and it potentially includes things like trips and so on, and trips away from the local area. Now, it may be that stage 2 narrows that down. I understand that. That's where I'm going next.
Okay.
Stage 2, eligibility criteria. We go through the prism of section 13, which is the judge sets out at paragraph 83. Section 13.1, where satisfied the adult has a need for care and support, it must determine whether any of those meet the eligibility criteria.
Yeah.
13.2, written record of the determination. 13.3, where at least some of the adult's needs for care and support meet the eligibility criteria, the authority must consider what could be done to meet those needs that do. And then 13.4, where at least some of the carer's needs, the local authority must consider what could be done to meet those needs that do. So there's your signpost, your section 18.19, as it were, gateway. And as the question my Lord Justice Baker was asking of Mr. Sharland earlier on, we don't see any of the second part of that in relation to section 19 powers. At best, we see the section 18 narrowing exercise.
Yes.
And 13.7, needs meet the eligibility criteria if they are of a description specified in regulations. Before we look at the regulations that the judge has picked up, it's important to look at 18, which she quotes from in paragraph 84. A local authority, having made a determination under section 13.1, must consider the adult's needs for care and support, which meet the eligibility criteria, and then there are some residence questions and so on. So to answer my Lord's question, the local authority only has to meet the eligible needs under 18.1, so you can have a mix of eligible and not eligible, and the duty bites in relation to the eligible and the power arises in relation to that latter.
Yes.
Fairly obvious, but that's just so you see how the statutory structure works.
Yeah, that's right. But
Then the judge sets out section 8, how to meet needs. I'll come back to that in a few minutes, but just to see the breadth of that, that includes, at 8.2 over the page, the following are examples of the ways in which a local authority may meet needs under sections 18 to 20. by arranging for a person other than it to provide a service, by itself providing a service, or by making direct payments.
Yeah.
So it,
And that applies to 18 and 19.
that's 18, yeah. So that is the breadth of the range of things, if you like, that you can do to support the needs.
And just going back, if I may, just is it your case that they never considered 19?
There's nothing on the face of the documents that suggests it does.
Well, you heard how Mr. Sharland characterised the eligibility assessment.
Yes,
the columns that we've got.
It only recorded those which they had identified as eligible. Now we can infer. Well, actually, no, we can't infer that. What we know is it doesn't include, as we go through time, the contested elements. But what we don't know, to go back to the reasons point, if you like, is whether they have been ruled out as being not needs for care and support or ineligible needs for care and support. Because we don't have that. It's not on the face of the assessment.
I don't think ineligible is right.
Sorry, is it non-eligible?
But because ineligible means they're
sorry.
they're not.
Yes, sorry.
They can't be supported.
Yeah.
Which is the opposite of the case. Eligible means they must be.
Yes.
Doesn't it?
Yes.
Whereas if they're not eligible, then there's a power.
I'm sorry, my lord.
And is there anything? There's nothing in that document, as far as I can see, which addresses whether they should exercise their discretionary power to support.
No.
Mr. Charles, you want to say something?
There may be other documents, but I'm just.
Yes. I think I was asked about whether there was a decision on Section 19. There was nothing in the bundle, but my junior has managed to dig out a response from the council in response to a letter from the claimant solicitors on Section 19, June 2020. So there was express consideration of Section 19 set out in June letter. That wasn't challenged.
Was that before the judge?
I believe it was.
My lord, in a sense, I'm happy to do it. But it's not part of our case. No,
right. I have copies of that letter if that
our case is that their assessments were flawed. I mean, the judge's findings that their assessments were flawed, and as it were, it all went wrong from there on. The fact that they didn't then consider Section 19, I mean, maybe that's a point that could have been taken before, but it's not been part of the claim. I don't want to make the same mistake again.
I'll tell you what we're going to do. When you finish your submissions, before we call on Mr. Sharland, we're going to rise for a couple of minutes just to take stock. And at that point, perhaps you and he can have a word about how you're going to deal with that point. Of course. Okay. Now, where do we go from here? You're dealing with eligibility.
In the judgment of paragraph 91,
yes,
the eligibility regulations, which are foreshadowed, which are empowered by Section 13(7). So an adult's needs meet the eligibility criteria if, and there are 3 steps, all of which have to be satisfied.
So which page are you on?
I'm on page 72.
Thank you. Yes.
91.
Yep, got it.
And adults' needs meet the criteria, so this is going from one ring to the next. If the adult's needs arise from or are related to a physical or mental impairment of illness. So that is recognising that you could have a need for care and support which is not related to your physical or mental impairment or illness, and it would be in the discretionary category and not in the mandatory category. But my point is that that is the, as it were, the filter that deals with Mr. Sharland's concerns about what he's calling general needs or universal needs. And it also deals with his concern about, for example, holidays or trips to Minsmere that are nothing to do with somebody's disability. Those things fall at this filtering stage.
But only from eligibility. They aren't knocked out as a need for care and support for which provision could be made under 19.
And that was my earlier point, perhaps clumsily made, that one has to understand that this is a narrowing exercise. You can't read the wider ring as smaller than the narrower ring, if I can illustrate it that way.
The fact that it's not eligible does not knock it out from being necessarily from being in need for care and support.
Exactly right. And that's why we've got a Section 19 ground before the judge, which I'll come to in a few minutes. So that picks up, to go back to the Jenny Thomas letter that the judge had referred to, which was part of the assessment process, the way in which for these individuals, as it were, on the facts, the holidays and the trips are related to their mental illness. Sorry, not mental illness, mental health.
Yes. Yeah.
That's the filter. Wouldn't be for everybody, but that's the filter. Then also, as a result of those needs, the adult is unable to achieve 2 or more of the outcomes specified in paragraph 2. And in play here are both the developing and maintaining of family or other personal relationships, that's little g, and little I, the making use of facilities, which I'll come to the detail in a second. Right? But these needs, even before we get to some subsequent argument about what the significance of the comma is, these individuals, just on the facts, can hit 2 of those, even on Mr. Sharland's version of regulation of 2.2i, because they have support needs which relate to, see Jenny Thomas, developing and maintaining family or other personal relationships, going back to their time at the institution which went so badly wrong, and they have a need for care and support to make use of necessary facilities, even if that's limited to the local area. So I don't need to persuade the court on the comma point, but we say the judge who dealt with the point was 100% right on the, I call it the comma point. She explains that in judgment paragraph 93. You've got that in the next paragraph. She teases it out in the way that the court put it to Mr. Sharland, and I don't understand there to be a specific challenge to what she says. And we say, just to succinctly put the point, the comma is exactly where it means to be, to distinguish between, or to bring into play, both local and not local, without some esoteric argument about the boundary between Suffolk and North Norfolk. And to deal, if I may, just to go back to the legal materials bundle, with the point about the carer's equivalent, you'll recall, well, there was a discussion in relation to the distinction between regulation 2 and 3.
Yeah.
We can perhaps pick up tab 6 of the legal materials bundle.
Yes.
2.2i, which is in the one directly in play here, making use of necessary facilities or services in the local community, including public transport, and recreational facilities or services, which we say implicitly not in the local community. Just to finish the point, those additional words would not be required if this was only about the local, because they would have been embraced by the opening part of the sentence.
So it's making use of facilities and services locally and
more widely,
recreational facilities
more generally.
More generally.
Exactly right. And the reason, if you then hold the finger in the judicial finger in that page and turn over a couple of pages, or the judicial PDF, to regulation 3.2, which is the carer equivalent, it is that 327 picks up the opening part of 2.2i.
Yes.
Sorry about this, it's slightly town stuff.
Yes.
And there was a local bit, but then in the split off paragraph, it changes tack completely, engaging in recreational activities.
So what's
It's a different kind of thing. It's a different beast. So recreational activities is not the same as accessing facilities and services. And that explains why the draftsman has split it off that way, because they're talking about a different kind of beast. But it also illustrates, in my submission, the breadth or the potential breadth of facilities and services, recreational facilities and services, locally and more generally. And that is a really important understanding when you come to look at the facts here of the sorts of things that these two gentlemen want to be able to do. It's accessing the facilities and services.
And yes, well,
and just
vary across the country.
Vary across the country. But then to go back, sorry about this, back to we're looking at that page now. in the bundle. We've looked at 2.1a related to 2.1b, unable to achieve two or more of the outcomes. They are unable to achieve two or more of those outcomes because of their need for support in doing those things. It's a very simple train of logic. They need support to develop and maintain family and personal relationships, as it happens, in their case, in the form of a holiday. They can't do it locally for reasons that the court's seen. They need support to make use of facilities locally, Minsmere, and beyond. I don't need to succeed on the construction of 2i. I hope that's that. But I would give you my answer, which is the judge's answer, which is three. It is split in that way. And just to go back to the point I made earlier, if we're capable of being within the eligible, we must, all the more so, be capable of being in the bigger ring. Right? The reverse logic is if this is a service supporting K or B to develop or maintain family relationships or make use of facilities, that necessarily recognises that it's a need for care and support, the bigger donut.
Yes.
And just to draw that together, there is nothing surprising about saying in the totality that this kind of provision is a need for support which is related to their mental impairment. That need for support means they are unable to do two of the things in the list, we've seen that. And then the third one, as a consequence, there is always likely to be a significant impact on well-being. Well, that just changed back to the Jenny Thomas letter. She specifically describes how their well-being had suffered for lack of these activities. Now, I don't need to prove it on the facts, but the facts are helpful to illustrate the context.
Okay.
I think that's. There's a bit more to say on ground one, but that's the bulk of the. Sorry, ground two, but that's the bulk of the argument.
Just a moment. Okay. Yes.
So I said I would deal with section 8, and I do want to deal with section 8. The judge mentions this paragraph 85 of the judgment. How needs may be met, and then at 114 she has echoes of that. Support in the form of an annual payment towards the cost of a family holiday. So this is a slightly different analytical way of looking at the council's power to provide these things. Not because they are necessarily in themselves needs for care and support, but because they are things which are capable of being delivered under section 8. The judge in 116, we say, correctly describes a wide range of ways in which needs may be met, and that takes her in at 117 to the statutory guidance. Of course, Mr. Sharland is right, the guidance can't determine the law, but it's illustrative here of the position. Foot of the page in 10.10, second line from the bottom, the concept of meeting needs is intended to be broader than a duty to provide or arrange a particular service. Because our person's needs are specific to them, there are many ways in which their needs can be met. And then at 10.12, where the local authority provides or arranges for care and support, the type of support itself takes many forms. Now that is not talking, I don't want to confuse things, that's not talking about the need for care and support boundary, it's talking about the range of things that you can provide under section 8. So just to go back to the passage I showed you in the much earlier care planning document, I showed you page 48 of the bundle, it's in the judgment, paragraph 33. To be supported, to have respite away from the family home or to access membership of the National Trust and so on. If there was any issue about the sort of scary word holiday, then Section 8 would deal with that. His need for care and support is a need to be supported to have respite away from the family home.
Yes.
The ambit of what could be done to meet those needs is very wide. See Section 8 and see the statutory guidance on it.
Well, Section 8 is very wide indeed, because the most it does is give examples.
Yes, absolutely.
It is not a definitive list.
No, absolutely.
Which is in play with what has been described really as the broader concept of the Act.
Yes.
Which is focused, we're coming back to it, to the autonomy of the individual, to the individual's well-being, and the broader spectrum of what can be done to assist any needs thereof.
Exactly right, lady. And that broader spectrum is the next point the judge picks up. Paragraph 118 of the judgment, she picks up the Clement's textbook, and I don't rely on it for what the authors say, I rely on it for their account of history. Para 8.8, she quotes this foot of 78 of your bundle. This is a Section 8 point. The absence of such things as adaptations, equipment, travel, holidays, which were specifically referred to in the previous legislation, was considered problematical by the joint committee that scrutinised the draft care and support bill, and in response to a question, it asked the Department of Health, ... received confirmation that the DH considered that these services did fall within the ambit of the list. The committee expressed the hope that subsequent guidance would make clear the list is not intended to limit. You've seen that. So there was a specific dialogue, entirely consistent with the exchange we've just had, about the way in which this is intended to broaden the scope of what can be done in relation to a broader range of needs. And that's the context in which at 8.88 the authors then say they refer to holidays. I don't rely on their view on it to determine the point, but that's the way they put it. Can I just briefly pick up the three cases that the learned friend referred to? First one, if I may, is GS, which you have at tab 22. Page 397. Starts at paragraph 22 in there. This is the Deputy Judge
Markland,
dealing with the question of accommodation and referring two extracts, one from Baroness Hale and one from Neuberger in 23-24. This is where we get the looked after bit, what my lady I think was looking for before. Yeah. And this is by reference to, if you look at paragraph 33 and the quoted paragraph 33, care and attention must mean something more than accommodation.
Yeah.
But it's care and attention, and that's the situation in which, looking further down that paragraph, Baroness Hale then picks up the natural and ordinary meaning of the words care and attention in this context is looking after, and we have moved on from that concept. So I don't need to say that the next two cases or this case and the next case are wrongly decided because they're about accommodation, but this is not a case about accommodation, it's a case about other things. But in my submission, it's a step too far to just take that and continue to use the looked after proxy label, which is not the statutory language, as if that were the test. Then you have Aburas, which is in tab 26, that's page 56, that's not 26, can't be 26, 28, that's 561. This is
Mr. Fordham.
Fordham. I think paragraph 6 may now make a bit more sense. Secondly, what is the relationship? So first of all, paragraph 5, he quotes again Baroness Hale, same thing you've just seen, albeit shorter extract. Secondly, what is the relationship between CA 14 and the duty to provide accommodation? the answer is that the need for accommodation is not itself a looked after need. Pausing for a second there. That's him agreeing with the deputy judge in the previous case, or at least not taking a different view, but health warning on that from me at least. But the provision of accommodation may be called for under CA 2014 so as to secure effective care and support for a looked after need. That's a section 8 point.
Okay.
So he's right in limb 2. I'm not sure he's right in limb 1, but it doesn't matter. But it's a section 8 point.
Did you want to say anything about paragraph 9 of his judgment?
Paragraph 9 sets out the sequence. And I haven't got an obviously I've got an obvious criticism of it. I don't think it repeats.
He doesn't get into looked after there.
He doesn't fall into that risky territory. Would be my point. Then the last of the 3 authorities is Hargreaves. You've got this tab 11, page 107. It's Justice Latham as was then. And what you see, start at page 332.
Yeah.
It in a sense illustrates the previous structure quite nicely, because what you had was section 29 of the National Assistance Act of 1948, and that's extracted by letter I. A local authority may, ... circumstances shall, make arrangements for promoting the welfare of persons to whom this section apply. That's the old framework. And then section 2, where a local authority having functioned under section 29 are satisfied, ... it's necessary to make arrangements for, and then facilitating the taking of holidays by that person. It shall be the duty. So that's the old structure, which to some extent, in a broad way, is followed again. Need for care and support, followed by eligible needs, followed by a delivery mechanism. But the framework was really subtly different. That's the point at which the holidays were spelled out in the previous regime. But as you've seen, no need to do that now and no intention to narrow. But the one point we get from this judgment is on page 334. Between letter G and I, in my judgment, the applicant's submission is correct. The respondent's principal argument, namely that the legislation was not intended to provide relief from poverty, but a relief from the extra expense of disability, begs the question. If the council have determined, as in this case, that the need for the holiday is a result of the disability, then the cost of the holiday to the disabled person must be capable of being an additional cost, which is the result of the disability, although the question may arise, it's necessary, etc. The subsequent question. That's significant here because Mr. Sharland seeks to argue that you can have a holiday but only get the cost of your mother applying the suntan lotion or whatever it might be. And this kills that off completely. If you have a need for a care and support, which is of a kind which potentially calls for a holiday, and the local authority evaluates that to be the case, and then evaluates it to be eligible through the multi-stage eligibility criteria, then they have to pay for the cost of the holiday. And that is what this local authority did. Not pay your mother's flights, if that's what's involved, but pay yours and your other costs. And the same is the case when you then go to Minsmere. If going to Minsmere is necessary for your mental well-being, to use that word, the local authority pays the costs of you going to Minsmere, not just some of the costs. And that's the gravitas of that. There may be reasons around charging regimes or whatever.
Yes.
That you may not get the money.
Yeah,
but
that's not the point.
That's not the point. Those are subsequent steps in the process. So, ultimately, I think that's our submission on those. There's one more I need to deal with section 19.
Yes, ground 3.
Very briefly. It was ground 5 before the judge. It's in the statement of facts and grounds, I'm sorry, at page 195 of the core bundle.
Sorry, the page in the core bundle?
195, I'm
Thank
sorry.
you very much.
Para 92. The defendant has refused to even consider using the powers under section 19 to continue to meet the claimant's needs for recreation in the way already identified. That's the point that was canvassed before. So that's the way the ground was put. The judge dealt with it quite succinctly. Paragraph 155 of her judgment.
Yeah.
She refers to a boras,
Yeah.
paragraph we haven't looked at, but I don't need to drag you through it. And she says, 157, in response, Mr. Parkhill submitted that Section 19 did not confer a power to fund recreational activities in the community on day trips and holidays, as these were not needs and did not come with the meaning of care and support. So that essentially repeated exactly the same legal submission as being the kicking off point for Section 19.
Yeah.
Of course, that's analytically right, but if it fails for ground 1 purposes, for ground 2 purposes, it fails for ground 3 purposes. And that's why the judge was right to say none of Mr. Parkhill's submissions survived my conclusions on ground 1. Because if the council's got it wrong on the scope of need for care and support, which he said they had, then they've not looked properly at the Section 19 eligibility stuff. My Lords, my Lord, my Lady, we put before you in a respondent's notice a reference to other statutory bases on which this could be done.
Do you think we need to hear on that?
I mean, that's really the belts and braces.
It's really the belts and braces point. We realise Mr. Sharley is right to say we've made a mistake on 2 of them.
Yeah.
I
I
put them back in the box.
I don't think we need, at the moment, to trouble you on that,
I'm grateful.
because I don't think it's germane to your
Core arguments.
core arguments. Thank you very much.
May I just say one thing? It's quite clear from paragraph 158, isn't it? That if nothing, nowhere else, that the judge was the proper order, certainly in relation to that, would have been to quash the 12th of November order.
You might have thought so, yes.
It just seems to me, I don't take a lot of time over this, but it seems to me, I wonder whether Mr. Sharland can really maintain that order as drafted properly reflected the contents of the judge's judgment, notwithstanding the fact that she records the judicial review is allowed in paragraph 1. Certainly a number of the paragraphs in the judgment showed that she certainly intended to quash the 12th of November decision.
Well, or I'm now perhaps being generous, I don't know, or at least to leave it of no continuing legal effect, which if I'm to throw a lifeline somewhere, was the effect of the declaration plus the order to do a fresh assessment, because that basically left it dead in the water. But I don't want to push the point too far.
Well, that could be your submissions on grounds 2 and 3.
Indeed.
Well, what we'll do now is we're going to rise just for a couple of minutes to take stock. We'd be grateful if you and Mr. Sharland would discuss the letter which Mr. Sharland referred to, dealing with the PowerPoint section 19.
You mean just in terms of the documents for the court?
Yeah, there's a document which he alluded to. He said his junior had fished out.
And the court asked for the 2 January email. We'll get that to you.
We won't deal with that now, but I think we're going to rise for a couple of minutes while we take stock, and if you could just decide how you're going to deal with that point, and then we'll come back.
Can I just say this? I mean, you're addressing a constitution that has, in each of our ways, spent our years in practice at the bar.
Yeah.
All right? So we know what it is like to deal with cases and how they can go. And everyone has been understanding and tactful. But if there is something that needs to be amended, let's take a pragmatic view about it.
Right, let's rise for a moment.
What do you want? The furniture.
Yeah.
Thank you. We've got the 2nd of January 19 email, 2020 email as well.
And the attachments?
Yeah.
We've got copies of it? Not yet.
I forwarded it to you as well.
Please. What's the email?
Just a second, slightly different format.
Okay. No, we need to print all that out. We need that and the attachments because I don't see the whole thing. Andrew, what do you want to say about this point? I mean, she clearly wants to, even if nothing else, they want to amend the order, even if they're, I mean, I can make a technical application for a cross appeal and an extension of time and waive all the fees and dump everybody, including the judge, in it. Bear in mind that you're on live TV.
Not sure many people are watching. We're probably still on.
Do you want to think?
Yeah, I'll have a think.
I mean, you haven't got long because I think they're going to.
No.
I don't think so. You've got copies of this for the judge, whoever's kindly provided.
Hi. Is that? Oh, you got time?
I've got a weak bladder.
I'm not going to be long in reply.
Yeah, I mean, it's very straightforward. I mean, it's exactly as Lee put it to the court, isn't it?
Yeah.
You follow the same legal logic, and it's either right or wrong.
Yeah.
I've not, no,
Yeah.
it's fine. There's no complexity like that. What do you want to do about this order?
I think if they want to vary it, and
I mean, basically, what they're saying is, if they're against you, are you? They're looking at me. They're saying if they're against you, not just on are you? Do you resist them correcting the order?
yeah,
Because when she's talking to me, she's saying,
I know. I understand that. Solicitors aren't in court, and I think trying to deal with it by email. I think this would be not. But I think I might like a bit of time.
Okay.
Are you happy for me to hand this up?
It's up. Yeah.
Well, right.
Well, Mr. Wolf, have you had further thoughts about the order?
I mean, look, we do think it would be appropriate if the court's, as it were, with us on the appeal. It would be appropriate to amend the order to reflect more faithfully the judge's conclusions on that in relation to 12th of November rather than the 3rd of March.
Well, when you say it would be appropriate to amend the order, what exactly who should amend it?
Well, that's the difficulty, because we haven't got at present before the court an application, a cross appeal, that would allow us to ventilate that point directly. I suppose what I could do is I could invite the court to give me permission for a cross appeal, which we could then formulate and submit to the court.
Well, the options are, I mean, there may be more options. The options are that you could agree between you, that the parties could agree that the order, to reflect the judge's decision, the order should have included the November.
Well, look, I've asked Mr. Shand about that, and quite understandably, he says he needs to take instructions on that, and his clients are on the end of a delayed video stream rather than. So I don't know what that means in practice, taking instructions on it. But
the second option is to give you leave now to amend. I think it would be to amend your respondent's notice to include a cross appeal.
Yes.
If we did that, then I think what we would want to do is to give Mr. Sharland time to respond, probably 7 days in writing on that particular point.
Right,
How does that, as a course, appeal to
I
you?
suspect I'm maybe missing an obvious trick here, but this only arises if the court's with me on the substance of the appeal, I think.
Well, we would.
Because if the judge is wrong in
I think
fundamentally wrong, then it doesn't arise because Mr. Charlton wins the appeal and the order set aside.
Yes, but we're not going to give an indication because there's quite a lot to think about here. But we could ask you on a contingent basis whether, in the alternative, you want to amend your notice to include that. So we can, if we get this far, we can knock the whole thing on the head, as it were.
Absent Mr. Charlton being able to agree it, I would say yes, we would like that opportunity, please. But
yes,
it's contingent on several layers.
it's. If you look at the second ground of appeal, I think it is. There's a clear reference. The judge's second ground. There's a clear reference to the second of 3rd of March letter, the fettering point. So I don't think it was necessarily the case the judge put the order said March instead of November. I think it may, but the question is whether it should have been November as well as March.
But I think that would still be subject to Mr. Charlton's ground one, I think, because he would say that the judge shouldn't have been looking at the 3rd of March.
No, you're right.
I think.
But that's the
But I'm now
there's firstly the question of what the judge
meant.
What order reflects her judgment.
Yeah.
And then there's the appeal.
Yes. Well, but I think, sorry if I'm being daft, but if Mr. Charlton wins on the appeal, then it doesn't matter what she meant because her order's got to be set aside anyway.
Absolutely.
For bigger reasons.
Yes. Okay. But
so are
you content simply to file a notice, a respondent's notice, say by tomorrow, incorporating a notice of appeal on this point without further argument? We have canvassed this point, I think.
Certainly
quite
intent to do. Could we make it Monday rather than tomorrow?
Okay, Monday, and then we could give Mr. Charlton until the following Monday to reply.
He might agree it contingently on the.
Well, the more time we give you, the more the more time we give you, the more time you have to get it as you would want it, one way or the other. Happy with that?
Yes.
Am I dealing with this letter or are you?
I was going to deal with it.
Okay. All right. Thank you very much, Mr. Wolfe. Now, Mr. Charlton. First of all, do you have any observations about what I've just been talking to Mr. Wolfe about? This point about the number.
I'm content with the course suggested. We have an opportunity to make submissions on that point if we think it's necessary. The simple way would be for me to agree now, but because I don't have my solicitors in court, and I don't want to rush it sort of via email.
Well, I agree. I think Mr. Wolfe's right. You should have till Monday.
Yeah.
Monday to you have Monday to Mr. Wolfe have Monday to file his document.
Yeah.
We won't do anything tomorrow. It's going to be too hot to do anything tomorrow.
We've got to the following Monday.
And then you got to the following Monday.
Yeah.
All right. Now then, on the letter, the point. What's this?
Well, I was asked by the court, did the council address section 19?
Yes.
The discretion. Yeah. And my juniors very helpfully found a letter the 12th of June that discusses section 19. I don't think it necessarily takes it too far, but it does deal with the factual question. So I've spoken to my learned friend. He's perfectly happy for me to hand it up.
Thank you. Well, we'll see it now then, please.
Yes, I understand it was before the judge below.
It was. Good.
It's been taken from a paginated bundle, which would imply as much.
Thank you. Where do you want to look at in particular? Oh, there, a second page. Yes?
Yes.
And the bottom.
There's clear discussion. Section 19 was raised in a letter from the respondent solicitors, and we discuss it here and the exercise of our discretion. And the basic point here is the council said holidays are not a need for care and support, therefore there's no power under section 19. So we were asked about it, we did address it. That's essentially our argument today. You either accept it or you don't. But it was something that was addressed in terms previously.
So now, what else would you like to say by way of reply, Mr. Charlton?
Thank you very much. I have 5 points and they're all brief. So I hope to be less than 15 minutes.
Thank you.
Um,
Again, you must have what time you want.
Very grateful, my lord. My learned friend started with submissions as to the nature of the decision-making process, and he took you to two authorities, Irena's Child and Burkitt.
Yes.
Court of Appeal in Irena's Child and House of Lords in Burkitt. We say neither of those authorities assist the respondents. If I deal with Burkitt first, the decision making in Burkitt was a planning decision, and you had a resolution, a preliminary decision, and then a final decision to grant. But that is not what you have here. The eligibility assessment was not a provisional decision, it was a decision assessing eligibility.
It wasn't sent to the claimant or the claimants or their mother until November 2020.
I quite accept
13
that.
months later.
I quite accept that.
And was followed, and what was sent was the draft care plan with the phrase
Yes. So
direct payments to be discussed.
Yes, it was. So I can't criticise the respondents for not bringing a claim in November, December 2019 against the eligibility assessment. But what I am entitled to do is criticise the claim that was issued in early 2021 after they've received the eligibility assessment. For failure to challenge then, because that wasn't a provisional decision.
Was the eligibility assessment then sent to the claimants or to their mother?
I don't. It may be the mother, but I don't know definitively. We would say nothing turns on that.
It wasn't by that point. Go back to the claim. Just look at the claim again. So, just in the knowledge, where's the claim?
That's in the core bundle. Claim
168?
168 of the ground, yes.
Yes, 168.
But obviously the grounds are part of the claim form, and the claim form articulates the decision challenge.
Okay. Right, okay, yes. So that's, your first point is that Irena's Child and Burkitt doesn't apply.
No. If you send someone a draft decision, clearly that is a provisional decision. There is ongoing discussion, and a draft care plan was sent, so that wasn't a final decision. But the eligibility assessments were not sent in draft form. There was a final document sent. That I quite accept it was only sent in November 2020, but it was provided to the claimants. The claimants had sight of it before they decided what decisions to challenge in their claim form.
Yes, thank you. Yeah.
The claim was issued the claim is dated 10th of February 2021. So right at the end of the 3 months to challenge the decision said to be challenged, the November decision. And the claimant's mother said that the eligibility assessments were provided to her in November 2020, so 2 or 3 months before the claim was issued. I don't think... So that Burkitt, and similarly Irena's Child doesn't assist. That wasn't a Care Act case, that was a completely different regime. And in the present case, under the Care Act, the assessment is the first stage of a sequential approach, but it is not a draft decision or a decision subject to discussion. So neither of those authorities assist. Now, related to that point, my learned friend, I think, criticised the council's summary grounds of resistance. On the basis that they took a time point in relation to the 3rd of March decision, but not the eligibility assessment. So my learned friend took the court to the summary grounds of resistance and said, well, a time point's taken there in relation to the challenge to the 3rd of March, but there's no similar time point taken in relation to the eligibility assessments. As a matter of fact, that's true, but the reason that there was no time point taken is the council did not understand the eligibility assessment to be challenged. And therefore, because the claimants had articulated clearly what they were challenging, and on any interpretation, it wasn't the eligibility assessments. It was either the November decision alone or the November and March decision. My third point in reply, I quite accept the language in the Care Act is needs for care and support. It is different to the earlier statutory regime which talked about care and attention. I quite accept the wording is different. Lady Hale's judgment in M and Slough related to the earlier regime. We say that the court in GS and the court in Abjuras was right to conclude that, notwithstanding the change in language, need for care and support means looked after needs to be looked after. And I don't believe the looked after phrase appeared in the earlier legislation. That was a judicial gloss by the court. And what those two judgments do is say, well, that gloss applies equally to this regime. Now, the court may disagree. We say that those decisions were right to do so, albeit I, of course, accept that the wording is different. And there is reference to care and support. And I quite accept the word support has meaning, but we say that doesn't mean it applies to holidays, food, clothing. Support in this context relates to adaptive technology, the hoist. If one installs a hoist, that isn't care, but it is support. It's literal support in the case of a hoist. The fact that the word support is there doesn't extend the concept of the relevant need to apply to everything someone needs. It doesn't apply to food, clothing, and we say holidays and activities. And we do say, on my learned friend's analysis, if they are right in relation to holidays, the argument applies equally to food and clothing. There was no basis for distinguishing between those. Now, my learned friend talked about hard borders. Our case is there are hard borders. That is our case. I don't run away from that proposition. That's how I put it today. That was the council's understanding as set out in their decision-making process. The hard border is imposed by the limitation need for care and support. If we are right that that means essentially looked after needs, that would be a hard border, we say excluding holidays, food, clothing. And we say there's similarly hard border at the eligible needs, the smallest concentric circle that we discussed. Yes. Can I just ask the court, this is my last point and it will be brief, tab 6 of the authorities bundle.
Yes.
I just want to draw a contrast between Reg 2, which relates to adults in need of care and support, and Reg 3, which relates to carers, and particularly paragraph 2. We've looked at paragraph 2I, which says the specified outcomes are making use of necessary facilities or services in the local community including public transport, recreational facilities or services. So it's making use of them. Now, if one looks at Reg 3, paragraph 2b, Roman 7, we have a similar provision, making use of necessary facilities. And over the page at Roman 8, engaging in recreational activities, which you don't find in the eligibility criteria in relation to adults in need of care and support. And we say that that supports our interpretation that payment for engaging in these activities is not an eligible need, because it's clear that the draftsman has included engaging in recreational activities in relation to carers outcomes, but not in relation to adults in need of care and support. And the reason for that is care and support relate to looking after needs, and engaging in recreational activities is something different. My lords, I'm very grateful for your patience, my lords and my lady, unless you have any questions. Very grateful. Thank you very much.
Well, thank you very much. Could I say we're extremely grateful in this case to counsel. I include not only leading counsel who've addressed us today, but also junior counsel who clearly did an extremely credible job, both supporting their leaders today, but also at first instance, and their instructing solicitors for the support they've given and the preparation of the case. We won't surprise you to learn we're going to reserve our judgments. In due course, they'll be sent out for typographical correction. We understand before we get to that stage the course that's going to happen now. The leave to file an amended respondent's notice by Monday, 4 p.m. Monday. Any reply, submissions in reply by 4 p.m. the following Monday. We'll send out our reserve, our judgments in due course for typographical correction, not of course an opportunity to re-argue any of the points. And also to submit an order, draft order in the light of those judgments. The draft, in due course, the judgment will be handed down under the new regime, which will be remotely. No need, therefore, for any attendance. Thank you all very much.